Today we're diving into what might be the most expensive hotel room TV binge in Australian legal history. I'm talking about IceTV v. 9 Network, a 2009 High Court case that fundamentally changed what copyright actually protects in Australia. Imagine this: a grown man alone in a hotel room for 3 weeks, frantically scribbling down everything he sees on TV. No, this isn't a Black Mirror episode. This was literally IceTV's business strategy, and it changed copyright law forever. Okay, quick context. IceTV wanted to create electronic program guides. Channel 9 said, absolutely not. You're helping people skip our ads. Now here's the thing. Everyone thought TV schedules were protected by copyright because of this case called desktop marketing about phone books. The legal doctrine was called sweat of the brow. Basically, if you worked hard enough, you owned the facts you collected. So IceTV goes full Mission Impossible. Mr. Rylett writes down 100 shows from memory, then camps in a hotel watching TV for 3 weeks. IceTV employees couldn't even look at Channel 9's descriptions. They wrote their own, calling the footy show an extra-long torture session. Channel 9 sues, obviously. They're screaming, "They're stealing our skill and labor!" But then, the High Court drops an absolute bombshell that rewrites Australian copyright law. The court establishes the independent intellectual effort test. Justice French and crew say, originality requires that the work originated with the author and required some independent intellectual effort. Not creativity, not merit, not even quality. But also, and this is key, not just sweating over a spreadsheet. You need actual intellectual effort in creating expression, not just collecting facts. The court states you must identify an author. Justice Gamo's like, guys, if you can't tell me who the author is, how can you claim copyright? Remember desktop marketing? That phone book case? They had hundreds of employees but couldn't identify the actual author. Was it the person alphabetizing? The typist? Nobody knew. For compilation specifically, Gamo says, the author is whoever makes the intellectual choices about selection and arrangement. Not the computer that sorts things, not the printer, the human making creative decisions. The final principle, and this is where Channel 9's case falls apart, there is no general doctrine of misappropriation in Australian copyright. The court literally says, the act does not afford protection to skill and labor alone. Translation, just because you worked hard doesn't mean you own facts. The court reminds us why copyright exists. It's a social contract. We give creators temporary monopolies over their expression to encourage them to create. But facts, information, the time a show airs, that belongs to everyone. As the French plurality puts it, copyright cannot give monopoly over facts because that would harm the public interest. Think about it. If Channel 9 owned the fact that Friends aired at 7:30 p.m., nobody could even tell anyone when Friends was on without permission. Society would grind to a halt. As for the precedent set by desktop marketing, the High Court basically admits it was probably wrong. They don't officially overturn it because IceTV had already conceded the schedule was original, but they drop massive hints like, it may be that desktop marketing is out of line with the understanding of copyright law over many years. That's judge speak for, yeah, that case was garbage, but we can't fix it today. A year later, Telstra v. phone directories happens. The federal court, reading IceTV's signals, declares phone books have no copyright because they lack human authorship, just automated processes. Boom. Yellow pages? White pages? No copyright. Desktop marketing? Effectively dead. So what's the lesson? In Australia, copyright requires 3 things: an identifiable human author, an independent intellectual effort in creating expression, and protection of how you say something, not what you're saying. That's all for now. Thanks for watching, and as always, keep imagining.